This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why one never delays responding to requests for admission in Arizona, and why requests for admissions in Arizona are deemed admitted if not responded to within 30 days of service. Rose Karam, an insured, appealed from the Superior Court's grant of summary judgment in favor of her residential property insurer, Mercury Casualty Company, and in Rose Karam versus Mercury, the Arizona Court of Appeal, on May 31, 2024, resolved her suit against Mercury and concluded that it was defeated by an admission that she had no case because she responded to the admission late, and it was deemed admitted as a matter of law. Karam was an insured under a Mercury homeowner's policy, and after suffering a fire at her home, Karam filed a property loss and damage claim under the policy, citing damage to a piano and a wall mirror. Following a receipt of payments by Mercury, Karam complained to Mercury that she was underpaid for personal property losses. They tried to resolve the claim but failed, and 2 years later, Karam sued Mercury for insurance fraud, consumer fraud, and breach of contract. Thereafter, on August 30, 2022, Mercury served Karam with a set of discovery requests, including interrogatories and requests for admission. Karam's response to the request for admission were due within 30 days of service, and she provided her responses much later in December of 2022. Mercury moved for summary judgment, and by its motion, Mercury asserted in part that because Karam's responses to the request for admission were untimely, the requests were deemed admitted. Due to those admissions, including that Karam had been fully and fairly paid for her losses, that Mercury had not breached the insurance policy, and that Karam had suffered no damages, Mercury claimed it was entitled to judgment as a matter of law on Karam's breach of contract claim. The court further determined that even considering her actual, albeit untimely, responses to the request for admission, Karam failed to produce admissible evidence creating a genuine issue of material fact. The Court of Appeals is in a position to affirm a grant of summary judgment if the evidence produced in support of the defense or claim has so little probative value that no reasonable person could find for its proponent. Arizona Rule 36A1 provides that, quote, a party may serve on any other party a written request to admit the truth of matters related to facts, the application of law to fact or opinions about either, and the genuineness of described documents, close quote. The purpose of the request for admission is to expedite the trial and to relieve parties of unnecessary costs in proving facts. Once a party is served with requests for admissions, failure to respond within 30 days, the rule provides that a matter admitted under this rule is conclusively established unless the court on motion permits the admission to be withdrawn or suspended. And therefore, 31 days after the requests were served, they were deemed admitted as a matter of Arizona law. Karam conceded on appeal that she did not respond to Mercury's request for admission within the required 30-day period. Therefore, the Superior Court did not abuse its discretion in deeming the statements in the request for admission admitted. Karam effectively admitted that she had been fully and fairly compensated for the claim she submitted that Mercury did not breach the insurance policy and that she did not otherwise have damages. Those admissions, even each standing alone, defeat a claim for breach of the insurance policy. And given the allegations in Karam's complaint and her admissions made by operation of law, there remained no material issue in dispute, and Karam can no longer carry her burden in the action. Mercury was therefore entitled to summary judgment, and the court did not err in granting Mercury's motion. In my opinion, a lawyer practicing in Arizona that does not comply with the rules concerning requests for admissions, or at least request an extension of time, will always lose because his opponent will always send a request including the ultimate facts about the case. Mercury's counsel took advantage of the Arizona rule and obtained admissions that resulted in the resolution of the case in favor of Mercury, and Karen loses. But she's not without a remedy. If the delays were not caused by her but by her lawyer, she has a cause of action against the lawyer. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 4,800 blog postings. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in more detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.